I will call the first case on this morning's docket, case number 113531, 113532, State of Kansas v. Tony Rote.
Chief Justice, I'd like to reserve 4 minutes for rebuttal, please. Oh, I
And-
gotta tell you who I am. I'm Jennifer Roth. I appear on behalf of Tony Rote. I work at the Appellate Defender Office, and I'd like to request 4 minutes for rebuttal time, please.
4 minutes is granted.
By way of a 1-minute overview, I would present the following. Mr. Rote has a pre-sentencing guidelines conviction for burglary. In 2009 and 2012, he was sentenced in 2 cases, and in both that 1984 Kansas burglary was scored as a person felony. He filed a motion to correct an illegal sentence in November of 2014, arguing that State v. Dickey applied to him and that his 1984 burglary should have been scored as a non-person in both of his cases. Without a hearing, the district court denied his motion in the next month and checked the boxes for Dickey not being final, not being retroactive, that Mr. Rote had not challenged his criminal history at his sentencing, and that his case, at least one of those cases, his sentence had expired. Mr. Rote was discharged from his sentences in February of 2015. On appeal, the state has continued to argue that this issue is moot, and Mr. Rote has continued to argue that it is not. In a 1-paragraph order, the Court of Appeals dismissed the case as moot, and this court granted review in December of 2017, and we are here today.
Can we start off at who has the burden here to show that it's moot or not moot? Is it the party benefiting from the finding of the moot, or one who's bringing that it's moot, or is it the defendant who has to claim that it's not moot?
I was just talking to a coworker about that the other day, because I feel like when the mootness test is talked about, it says, well, it has to be shown that such and such, but doesn't really say who has to do the showing. Right. And so I don't actually know how to answer that question. I guess what I would say, I don't know if it's technically our burden or if it is technically the state's burden. But what I do know, for what it's worth, is that the mootness test has a very high standard and has very broad language. And so, and I guess ultimately at the end of the day, it's the court, the district, or the relevant court, that has to determine whether that test has been met, that test with a high standard that has broad language. But honestly, Justice Rosen, I don't actually know. I know you had argument earlier this week on this idea of who bears the burden in certain contexts, but that's, I guess, my answer.
Okay.
But jumping right in, as I alluded to, the mootness test requires that 3 elements be shown clearly and convincingly. And that's the same standard that we use when we want to terminate somebody's parental rights or discipline them as an attorney. So that is a high standard. And not only is the standard of proof high, the elements themselves use broad language. And there are 3, as we know. Number 1, the actual controversy is ended. Number 2, that the only judgment would be ineffectual for any purpose, and it would not impact any of the parties' rights. And this test, with that wording, is included in this court's decision in State v. Montgomery, which is the case that the Court of Appeals relied on to dismiss my client's appeal in their 1-paragraph order. But what is clear and convincing, and hopefully will be made so by the end, is that Mr. Rote's appeal is not moot, as none of these 3 elements are met in this instance. And I'm going to address those 3 elements in order, even though I guess one could argue that some of my points maybe would fit under the 1 or more different categories. So of course the first part of that test is whether or not the actual controversy has ended. The actual controversy at issue here has not. The district court and the state and the Court of Appeals all treat the controversy as though it was just about the length of Mr. Rote's sentence. But what the controversy is how you score that Kansas burglary from 1984 and how it was classified as a person felony.
Wasn't it initially about the length of the sentence? That's what he's complaining of. When he brought this motion to correct an illegal sentence, he was seeking relief from the length of sentence so he could be released sooner, I presume. There was nothing about any other consequence of this. Isn't that right?
I guess what I'm saying is that the reason that is true, but the basis on which he's asking for his length of sentence to be different is the miscalculation of his prior burglary, and that is the problem, is how it was scored. And so,
Counselor, the case or controversy requirement means that your client can't litigate that question for the next person, right?
okay.
And so how does it, even if it remains unresolved, how does that impact your client? I think is where we're at, not whether the legal question remains unresolved. Because if it's unresolved but not affecting your client is what we're really talking about.
Right. Okay, then I guess I'd move on to the thing is, it is affecting my client, him personally, by having a conviction continue to be considered a person felony when this court's case law says it is not. It still affects my client.
And explain how it is.
Okay.
Excuse me.
That was my question.
Yeah.
Okay.
How is it impacting your client?
All right.
And,
So,
in either a vital right or maybe something that's more a little less certain than that, in some sort of legal interest.
right.
Explain to me how that is happening.
So there's two things that are discussed in the petition, and before that. And the one is, of course, Mr. Rhodes' ability to file a malpractice claim. That's one thing that he argues, that we argue in the petition. Another one of those things is, in order for me to be sentenced correctly in the future, I need to be sentenced correctly now.
How much, let me, and I'm cutting you off, but when you say file malpractice claim, do we then get into the kind of further analysis as to whether that is even accurate or whether that's would ultimately result in a frivolous claim? How far do we go with understanding what it is that he seeks and he claims to be a legal interest?
Well,
Right now, it seems these sentencings took place prior to DeCamp, which was the vehicle by which he's seeking relief. I mean, that hadn't even happened yet. So do we even look at that, or do we say, no, he can argue that in his malpractice case?
I don't.
I mean, do we look at the credibility?
merits?
Yeah, the merits
Right.
or the credibility. How deep do we go in here?
I don't think that's this court's role, because what this court has said is he can't even file that unless he gets relief on his judgment, or on his claim about his sentence. And so I don't think that it is this is my position. It's not this court's role to decide the merits of something like that. It's just that's what he has to do to even bring that claim. But I don't think that is where this court should be drilling down. I do think there are places where this court should be drilling down, but that's not one of them. Of course, the other argument that he made was that we make in the petition is this idea of, well, for me to be sentenced correctly in the future, then this needs to be fixed now.
Before you move on to argue that point, back on the malpractice, you indicated he can't even file a petition unless he gets relief here. So has his malpractice action accrued? Usually an action accrues when the act causing the harm has occurred. I'm not sure what difference it makes, but I think on other contexts we've had some arguments as to whether the malpractice cause of action has even accrued yet. And so how speculative is that?
I'm not certain.
Don't our other cases say that you have to get relief, at least when you make an actual innocence claim? You have to get relief.
Right, and then this court said in the Garcia versus Ball case that we cite in the petition that he has to get relief on his illegal sentence claim in order to bring a malpractice suit. That was my understanding of what that case says. But what I want to also explain is that there are other consequences that directly relate to my client that impact him. So for example, we have 25 years of the Kansas sentencing guidelines. And so as you might imagine, other Kansas statutes that aren't even criminal in nature relate back to things like person, felony, severity levels and things like that. So for example, there are a number of licenses, a number of things under Kansas law that you cannot get if you have a person felony. For example, it explicitly says if you want to become a barber, you cannot have a person felony. Things like that. So there are these other things that we can find in Kansas law that aren't speculative. They're not hypothetical. They're actual consequences.
I guess that gets back to my first question. Who bears the burden to point that out? Is it the state that would say there's no circumstance in which this would have a legal interest? Or is it you that has to come forward with a legal interest that Mr. Rote could assert in order to not make it moot? I mean, or is it somewhere in between?
I'm not certain. I am now telling you
Right.
that.
No,
but-
you're telling us that if he has a person felony, he can't be a barber. So is that something that you've never claimed that until oral argument this morning? I mean, so who comes up with this laundry list of impacts here? Or
Well, I'm not certain I'm not certain if it is me or if it is the state. I'm guessing the state wouldn't come up with said laundry list. But at the end of the day, the district court has to determine whether there is any purpose for which this would be ineffective. And I do not think that you can meet, when one considers the consequences that could happen to my client.
Why not litigate that after he gets denied his license to barber?
Well, he wouldn't. I don't know how he would litigate that. There's no other process or
persons who are denied a license can challenge that decision of an administrative agency. Mm-hmm. And his argument, I presume, would be, no, I don't have a person felony. What you're looking at is just wrong.
Well, I don't know of another place other than a district court in your criminal case that's going to make a determination.
Well, I guess that gets to my follow-up question, which is probably the more important one. Is mootness a doctrine of judicial discretion, or is it jurisdictional?
It's not jurisdictional.
And so what do we do with the overlap in the case law and in the tests that we apply that talk about whether or not there's a case or controversy, which is jurisdictional type language at least?
Well,
Would you agree that if there's no case or controversy that the court has no jurisdiction?
no, not necessarily, because that test has three parts. I see what you are
Right, but
saying.
we have case law that says there is a case or controversy requirement in order to obtain jurisdiction. And I'm asking about the overlap between mootness and jurisdiction, basically.
But we also have an exception to mootness if it's an issue of public interest and not amenable to being resolved in the future. And once you have an exception, then that countermands the jurisdictional label, because if you apply our law that says you can't waive
Right.
or
Right, so I think Justice Johnson's pointing out what I would identify as at least as a tension in the case law, which suggests that the court can reach issues when there's no case or controversy. And that's what I'm struggling with. How do we reach an issue if we determine there's no case or controversy?
Well, I think I'm not. One thing that continues to strike me is the way that we think about a controversy. that needs to be thought about in a broad way, just like the language and the other two elements of the test. So we cannot think about the controversy being how long did he spend in prison versus how long should he have. That the controversy is also about how something was categorized to make him spend that time. So I guess part of me is advocating for this broader look of what constitutes a controversy in this context in 2019 in a mootness inquiry for a person in a criminal context.
Counsel, if I can interrupt, I think I want to kind of return to a couple of questions that have been asked. Justice Rosen has asked a couple of times about whose burden it is. Am I correct that your position today is even if you have the burden, you are bearing it?
Yes.
Okay. And then as to my colleague Justice Stiegel's question, might it be your position today that to the extent our previous decisions have referred to mootness possibly a little more expansively as a case or controversy question that does have a jurisdictional concept attached to it, that those cases are in error or a little sloppy?
Yes, and right, we need to have a broader view of it. Right.
If that's the case, would the jurisdictional requirement of a case or controversy trump any considerations about mootness? It would seem to me it would have to.
Right. I guess I go back, rightly or wrongly, I go back to the fact that this test has these other elements to it. And I understand what you're saying, that normally we think of jurisdiction that, oh, we have to just stop there if we don't have it. But I keep going back to the idea that this test has these other components to it. And so, yes, those other components could, in fact, trump the tension that we have.
What you're saying is that the completion of sentence and post-release does not, as a matter of law, constitute the end of a case or controversy. That's what you're saying,
That's
right?
exactly what I'm saying. And I'm saying it for numerous reasons. I mean, for things that this court called, I think about Montgomery and how it talks about collateral consequences and how there are two kinds of collateral consequences. And one are things that are imminently threatened, things that are going to happen as a matter of law. And then there's things that are way more speculative. What we have in our own Kansas law are actual consequences, actual things that happen when you have a person felony that has not been corrected to be a non-person. We have, in a broader sense, we have we know that there are things in the system about where people can live and what kind of jobs they can, that sort of a thing, because they have a person felony. And so
I guess I don't understand that part, because he pled to making a criminal threat, which is a person felony. So that's the Kansas case. So
Right.
you don't really, so those arguments don't seem applicable to whatever happened in Colorado with this other thing.
Well, I was hoping somebody would ask me that, because this morning I realized that even that has an impact, because the criminal threat's a level 9. And so, for example, Mr. Rote, his second case in 2010 was a possession of methamphetamine. And so when you have person felonies, then you are normally presumed to not get mandatory drug treatment under Senate Bill 123. However, if your criminal history is 8 through 10, then you are. And so a consequence to him of having that prior burglary scored as a person felony is it took him out of the running for getting Senate Bill 123 treatment, because he wouldn't have been disqualified for his criminal threat.
But doesn't that my difficulty with these cases is you've got the flowery language, maybe the sloppy language about any consequences and that sort of thing. But then you've got the facts as to what's been decided within the case, aside from the flowery language. And so in Montgomery, we said, well, no, the possibility, just because you had your probation revoked once doesn't mean that the next time it comes up, you're amenable or not amenable to that. That's too remote. It seems like the second you start talking about, well, the next time he gets a criminal case, and the next time this and that you're down that remote path, that we risk really, there's no control over that. So it's like you can never get rid of a case.
First of all, I understand the concern about some things being down the road, but some of the examples, but for the exception of the one I just gave you about the drug treatment, so those other examples about what jobs you can get and where you can live and things like that, those are not about getting a new criminal conviction. So you can incur collateral consequences in a very real and not hypothetical way without ever getting another criminal case in which you can challenge your prior and that sort of thing. So these things can happen to you without ever getting another criminal case.
Well, I guess this is where, who has the burden, your ability to demonstrate that for Mr. Rowe, as opposed to telling us that there's different ways different things can be played out. But as to this guy, this defendant, here's how it's going to play out for him, and here's the consequence to him. That's what I think you have to focus on, rather than a more global kind of thing.
Well, I don't know if Mr. Rowe wants to be a barber, and I don't know.
But he can't, under your example, he can't be, regardless of how that Colorado offense gets scored, because he's already pled guilty to criminal threat.
Right. My person has a Kansas burglary. His priors at Kansas burglary that would qualify for Dickey relief.
Am I looking at the wrong? I've got your case up.
Okay. I'm just telling you
Okay.
that his prior is a Kansas burglary from 1984.
That's his prior, but it's being scored within his 2009 conviction.
Okay.
So he's not going to get a barber's license regardless of whether he ever had
Because
Okay.
in 2009, pled to a person.
the other Kansas conviction.
Right. And so that's why this morning when I realized, I bet somebody might say to me, oh, but look, he could never be a barber. But what I'm saying is that even so, the fact that he had that person felony, the burglary, did in fact negatively impact him, even when he had a possession or a conviction for criminal threat, because it would take you out of the running for being able to get Senate Bill 123 drug treatment, which you would be able to get if you had a level 9, but not if you had a level 7.
So he could have had the 123 Senate Bill 123 treatment while incarcerated for his level 9 conviction of 2009.
Well, he was on probation for that 2009.
Okay.
And so instead of going straight to prison for his 2010 case for possession of methamphetamine, in theory, he could have been, which would have trumped the other rules and would have said, you should go to Senate Bill 123 treatment.
The other thing that's been bugging me about this, and I know you're out of time, but we've got all these cases and we might as well get this out of our system. The other thing that's bugging me about this is, let's just assume we've got some defendant who's been out for 5 years, and he could enjoy the benefits that you're talking about by bringing a motion to correct an illegal sentence today, even though it's not, he's been out and off probation and all of that. I mean, is this just a bottomless supply of motions to correct illegal sentences that are sitting out there?
I don't look at it that way. I don't think so. Again, I don't see another mechanism or a procedure by which a person can get their felony reclassified, but for getting a new criminal case.
Well, Counselor, aren't we talking about mootness of this case? And if his other case is done and he's out, then the issue and dispute has been resolved. What we have here is an unresolved legal issue that's gone through the district court, the Court of Appeals, and we granted a review. And we've got a whole bunch of other cases that have the underlying issue here on the Dickey. Those
Yes.
are on here. So those are legal issues that are on the table. And once they're resolved, then a whole different
Right.
ending mechanism kicks in as to whether you can challenge again and that sort of thing. But
That's
what
right.
we're talking about is what ends a case prematurely. Isn't that what's on
Yes.
the table?
Yes. And obviously, this court is interested in that, given that 4 cases and now 3 have to deal with mootness. And so it is, the other thing, Justice Biles, you mentioned the fancy language of the 3-part test to mootness. And it is important. I mean, to be able to resolve these things definitively is very important, and not, I don't know, it doesn't, that test is broadly worded and has a high standard. Whether I have to meet that standard or whether ultimately it's the court that decides whether that standard is met, but it is a very high one, and that language is very broad. And there are, in 2019, a lot of ramifications to a person, even Mr. Rowe, for having certain kinds of person felonies never be reclassified correctly. And so, yeah, I think that once this court resolves a number of things, the retroactivity of changes that continue to happen, the state continues to ask to change the statutes to choke off the ability for people to ask for their sentences to be corrected, that once this court resolves a number of those things, we won't have a bottomless pit. We will have more of an idea of how a person's supposed to go about this.
Counsel, I'm going to
Well, let's make this the last question.
I was going to follow Justice Biles' encouragement and keep you up here for one more question. In our recent case of State v. Lehman is a case in which the state tried to take advantage of a motion to correct an illegal sentence after the completion of the sentence. And in that case, we said that when Lehman completed his original sentence, he was no longer subject to the jurisdiction of the criminal justice system. Is that wrong, do you think? Again, I was just back on the jurisdiction question. If the defendant's not subject to the jurisdiction of the court, how do you get to come in and ask to correct the illegal sentence?
So did this, may I ask a question back? I don't know if in that instance the state was asking for this defendant to get more time, or I'm honestly not familiar.
That's fine. I appreciate that. I dropped that on you at the very last minute in surprise.
You'd think that'd be the sort of thing I should know. But I guess what I would go back to is that when we are talking about illegal sentences, that part of that component, an issue here, as well as other cases, is how something was classified to make it so, to make that sentence be what it was. And so even though Mr. Rowe has served all of his time, he still has an interest in having that thing properly scored. And so I guess I would say in that way it's distinguishable, I think, in the situation that you give, because it's not an issue about like, because his time is up, but it's still something he needs to have resolved because of how it was classified. So my gut reaction is that is how it would be distinguishable from that situation that you presented.
Thank you.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas.
Hi.
I think you have a question. Yeah.
I do. You do. Are you familiar with the Lehman case?
Only peripherally, frankly.
It's a double jeopardy case.
Okay.
And double jeopardy is, in some sense, kind of a one-way ratchet, isn't it? You can't put a defendant in jeopardy twice, so the state is precluded from doing so, whereas a defendant under 3504 can challenge an illegal sentence at any time. Isn't that right? At least under the statute as amended in.
Well, and I think that there's some question about that as well, about the meaning of any time, and I think it has gotten to the
and we're going to get there, and
Yeah.
I don't mean to get too far down that. Do you agree with me about double jeopardy just generally being kind of a one-way ratchet? It's a defense
It is a defense,
tool, not a.
and it is a constitutional protection from under the United States Constitution. It would protect a defendant from being prosecuted
and a
twice.
statutory protection.
And,
I,
yeah.
It's just the state's never going to say we're invoking double jeopardy because they're the people who are trying to continue the case later. Anyway, that's okay.
Just a
Well,
quick
actually,
follow-up.
yeah.
Is double I mean, it's true, Lehman was a double jeopardy case.
Okay.
Is that a jurisdictional bar? And if it is, then we might have been correct when we said not subject to the jurisdiction. But if it's not, maybe that language is, as we said earlier, sloppy or incorrect.
So let me finish very very quickly if I can. I think there could be an instance where the state could assert a double jeopardy claim if a crime. I suppose it's at least theoretically possible, and we saw some of this back. I think it was the McAdam and those types of cases where we got that rule. I suppose that had the state secured the conviction properly, and forgive me, it's escaping me if it was Barnes or there was another case that denied retroactive application of the McAdam rule. In that particular instance, that's the equivalent of the state asserting a double jeopardy. Like there is no way to that we can go retry somebody for a lower level offense. Turning to Your Honor's question, Justice Steele, when it comes to the question of whether or not mootness and overlaps with jurisdiction, I think that it actually starts to get to the core of the mootness test, and there's some specific language that is somewhat conveniently overlooked by opposing counsel today, and that is that the rule from Montgomery is that a case is moot if the rights involved in the action are as far as the rights involved in the action are concerned. So while you might have jurisdiction to consider this case is moot nonetheless. So the defendant is precluded from any avenue of relief in this case.
On burden, we've talked about the burden of proof. It seems to me that we're talking about what terminates a case or controversy, because you will agree that we have an appropriate legal issue in dispute here. Even though you want to win that, you think you should win that dispute, but it's unresolved, and you agree with that.
That being the retroactive application of Dickey?
Right. That dispute is unresolved here. And so the case or controversy has not ended by resolution of the dispute. And so it's a premature termination, isn't it?
I don't think that it is, because the defendant's claim is that my sentence was illegal. The sentence that I'm serving is illegal. If he's no longer serving that sentence, then it should not matter to this court one way or the other if that were true. Because at some point, cases and controversies must come to an end.
Okay, so it seems to me that in order for the defendant to have the burden, that the completion of the post-release supervision, it's not just a sentence, right? I mean, we
Right.
Yeah, it's post-release supervision, is either a end to the case or controversy as a matter of law, or it's prima facie evidence that the case or controversy is ended in order to shift the burden. Because you're the one wanting to end this case before we complete the dispute resolution, right?
Well, and I think that this court should want to end it as well, frankly. This ties into the issue of advisory opinions. What are we doing here? This case, I'm to correct if I didn't want to overstate.
Back to my question.
Yeah.
Would you say that the completion of post-release supervision is prima facie evidence that the case or controversy has ended? Because we have Montgomery out there that says it's really not as a matter of law, right?
Right, it's court policy.
Right. And so we'd have to say that that's prima facie evidence.
And I think that
And what
I'll take it even a step further back. I believe that the completion of the incarceration portion of a sentence is in and of itself prima facie case that a case is moot, because post-release is defined exclusively by statute. The term of post-release cannot be changed by the correction of an illegal sentence. It's defined by the severity level of the current crime of conviction. And so I think that is enough for there to be prima facie case, and then at that point,
I'm sorry, did you say you can't correct post-release term with a motion to correct?
No, you
okay.
can't.
I'm sorry. I probably just missed something there,
No.
because I know that the state's going to throw it in.
In addition to that, if there's an effective post-release supervision date that should have started previous to the time it was imposed, that has an impact. I guess this is not the situation here, but I know you're suggesting that once incarceration is complete, the case is done. The case in controversy is over.
I think that is prima facie evidence that the case or controversy is over, and then I think that the fact that this particular defendant...
Isn't that a more literal reading of Montgomery than even Montgomery is? We have cases where in other contexts where the court has said, no, it's not moot because this could serve as kind of a res judicata on another case. We have lots of cases that say that.
Well, actually, no. Show says you don't. Show your opinion in State versus Show says no. Your criminal history is, you can relitigate that in any future criminal case. That's not even in question. And I think that one of the other cases that was on the docket this morning, being the West case, that case found just that, and it cited to Show. I think, again, we have to be careful with how we define our terms here. In this case, the case of controversy was the legality of the defendant's sentence, specifically the length of his incarceration. He was not challenging his post-release supervision period at any stage. Once he had completed serving that imprisonment sentence, that case or controversy was over, and that should be the end of it. The burden should be on the defendant to demonstrate to this court that their case is not moot, because they can come up with reasons. I've heard a number from the podium today that were not included in any of our briefs that, frankly, I think as Justice Biles started to point out, are irrelevant to this case as well. Collateral consequences and speculation about future events should not trump this court's mootness doctrine.
Is there anything that you know of in the law that prevents the litigation at a later time of the impact of the quote-unquote illegal sentence on collateral issues?
Nothing that I'm aware of. No. And the example that was given earlier would be an administrative denial of some sort of a license or licensure. You could challenge that administrative hearing and attempt to...
What about our case law on malpractice lawsuits? Does that pose a hurdle or an impediment in your view?
I think that and we're turning to Garcia versus Ball, because that's really the only issue that, frankly, the state believes is before the court today. A couple of things. A defendant can file a malpractice claim without a finding of exoneration. He simply can't succeed.
Well, he could succeed if he convinced us to change our case law.
I suppose that's possible, but that would be changing the malpractice case law.
But you would concede at least that under existing case law, there's an impediment.
Under existing case law, being Garcia versus Ball, there would be some impediment because he would struggle to find a way to gain that exoneration. But again, this ties back into one of the questions that I heard earlier. How far down do we want to speculate? Where are we going to start drilling down? Because if we're talking about just bringing the action, he could bring it right now, a malpractice action. Or if we're going to start looking at the merits and considering whether or not he's had a finding of exoneration.
Should we? If our other case law about, it's effectively about when it accrues. I mean, I may not have used accrual language. I don't really remember at this stage, but it's effectively about when you've got a viable cause of action. And we said you don't have it until you've gotten relief from some court.
Right.
So let's just, for purposes of argument, assume that's going to stay in place. Is it this court's place to go on to that next step and say, if we buy the argument that you might be able to bring a malpractice action and that keeps this controversy alive, Is it this court's place?
I think
Your
if you're-
opponent suggested no.
I think if you're willing to go as far as requiring an exoneration and a legal sentence finding, then what's to prevent this court from
Well, there's
continuing
nothing
to
to
drill?
prevent it.
Right.
When I was in your place, Chief Justice Holmes leaned over the bench and said, "We can do anything. We're the Kansas Supreme Court."
Right.
When I suggested there was something he couldn't do. So, yeah, in theory, we can. But
Right.
I mean, really, is that appropriate for us to try a malpractice case up here that has never had any evidence put on, et cetera?
I think that in the context of Garcia Ball, that's effectively what has been done. And I don't know that
No, those
necessarily
cases talk about when you can bring it. When you have a viable
but what
cause
it
of action.
did was it expanded the exoneration rule. It took the exoneration rule that previously only applied to an actual exoneration, and it stretched it. It eroded away
That's
at
talking
what
about when you
illegal
can
sentences
file,
were.
not how it's going to come out. I'm asking whether we should go on and examine the merits of any potential malpractice claim. That just, talk about getting out in the weeds. That sounds like getting out in the weeds to me.
I think it began by getting into the weeds and going further.
I
don't-
understand you have criticism of that case. I'm
Sure.
asking you today, assume that case law's in place.
Right.
Assume we hold in favor of your opposing counsel that this case is not moot. Should this court, I'm just repeating the question that Justice Rosen asked your opposing counsel. Should this court start looking at the merits of any potential malpractice case?
I don't like it, but I think that is what would be required. To be
How
frank.
so? What would tell us that? Any
So-
authority?
So Garcia versus Ball, and I know there's a difference as to what that case may or may not mean, but it absolutely extended the exoneration rule into the realm of an illegal sentence, and it opened up an entire new world of potential malpractice claims against defense attorneys. And it did that by requiring some finding of exoneration. That meant a granting of an illegal sentence motion at some stage. So there has to have been, and Garcia had one. He got one, and this court deferred on the propriety of the district court's ruling, but he obtained a nunc-pro-tunc from the district court. And this court didn't even consider the jurisdiction of the district court to have given Garcia that order. So I think this court's already started to look there, and if you continue to do so, then claims such as this defendant's, you have to look at the four-part test, and he fails. He would absolutely fail. There's absolutely nothing that requires defense attorneys to be clairvoyant. There's nothing that would say that that the defense attorney in this case should have foreseen the result in Dickey that he's now trying to get application of.
Even earlier, Dick
Yeah,
Thomas.
he wasn't required to be clairvoyant. So he
But
couldn't
isn't that,
he couldn't
isn't
even make
that
a
a
prima
kind
facie
of an
case.
issue in the malpractice case as opposed to our looking at it, what might be the issue? I agree with you. You
Yeah.
can't be clairvoyant. There's cases that hadn't even been decided yet when this, I understand all that, but is that for us to look at?
I feel like, and I don't want to, belabor it too much. I feel like we've already started down the road with Garcia Ball.
And let me ask you, does it make sense that Mr. Rote, because he's completed his sentence, and let's say he's completed his sentence a few days after, and post-release a few days after he brings this action, versus someone who's still incarcerated, who can bring the illegal sentence because there's still viable. Does it make sense that the person who is still incarcerated can get relief and he can't? And then, so the end result is the person that's still incarcerated can bring a legal malpractice claim. The person like Mr. Rote can't. Why is it because you've completed your sentence that's the difference?
So I think that we're okay. Again, we're basically addressing the propriety of Garcia versus Ball, and I granted that
Well,
there's
that's
a
the
question
law.
there.
That's what we have.
Right.
And so with that requirement, doesn't that create a disparity of, like, if you're incarcerated, you get to bring the action, if you're not, you don't?
But I
And
think
you might
that
even
this,
have a better claim for the one that isn't incarcerated.
I don't know that you would, because the fact of the matter is that there is a current harm to the person that's being incarcerated. A past harm, while potentially actionable,
Malpractice claims are all about past harms. It has nothing to do with current.
It's
harms
about
per
events
se.
that happened in the past that caused a harm. But like my point being that someone that's currently in prison is currently suffering a harm from that past action, whereas somebody that's been out of prison, completed their post-release, they're no longer suffering any harm.
Well, let's
from
just
that.
hypothesize the case where the person would clearly win their malpractice action. Clearly.
Okay.
Now, respond. Why doesn't that person get relief?
Why shouldn't they get? Because they didn't bring it in time. I mean, I don't know how to say. I don't know how else to say it. There
Well,
has
they,
to.
they did. They brought it when they were still incarcerated. Here, Mr. Rope was still under sentence when he brought it. It was completed at the time during the appeal.
Right. Which I think rendered this appeal moot. And I think that all of these questions tie back to the central core of the state's argument. We are speculating in this case. We're speculating entirely, and that is not the role of this court to issue patently advisory opinions based on pure speculation.
Was this factual scenario at all considered in the Garcia Ball context or case?
This particular factual scenario, I don't think that it was.
Yeah, okay. The Garcia Ball court didn't necessarily think through how it might apply
No,
to a moot case.
No, the Garcia Ball court just flat out opened it up to an illegal sentence claim.
Go
Go ahead.
I'd like to go back to the Barber example that was mentioned. Let's assume that the defendant has the burden here to show that this case is not moot.
Okay.
Are you saying he never could make that case? Or is there some point where he could say, I want to be a barber. I've already enrolled in a course, but I am concerned I'm not going to be able to enter barber school and become licensed because of this issue. Does that do anything at that time?
And
Is there any point in which you would say, okay, it's not moot?
respectfully, no. In this context, when we have a claim of an illegal sentence based on law that happened after a sentence was imposed, particularly in light of the changes to 223504, particularly in light of the mootness test itself, that there is no controversy in this particular case anymore, any judgment entered in this particular case would be ineffectual for any purpose, and there are no more rights of the defendant at issue in this case. That meets all of the tests, the definitions of mootness, and I believe that the case should be dismissed as moot. Anything to the contrary is pure speculation.
Is that, do you have more on that?
I was just going to follow up on that, but go ahead.
No, I wanted to follow up on it because it seems to me that we all may be talking past each other because you're saying it's moot as it applies to the illegal sentence here. Opposing counsel is saying the prior conviction is what disqualifies the barber candidate, and does the correction of the criminal history score in this case obliterate that person felony on the record, or does the defendant have to go back in that prior case and get it corrected? Otherwise, as far as the record goes in that case, they have that person felony. You see what I'm saying? You're talking about the current sentence, and she's talking about the prior sentences. And so if we correct an illegal sentence in this case, does it automatically correct all of the characterized or misclassified convictions as previously? Am I making any sense to you?
I see what you're saying, but again, I think we're talking about issuing an advisory opinion and the potentiality that something would happen in the future that this would be relevant.
Well, let me ask this: if we have the chief's barber aspirant, could that person go back to the original case and file a motion to correct an illegal sentence, even though it was way long gone completed, for the purpose of making them, for the purpose of removing the civil disabilities that flowed from the court's error.
In that hypothetical situation, I again would say no. The sentence was complete. There are potential remedies should any future harm come to bear.
What is the remedy? How does in the chief's example, how does that person get to become a barber when they legally should be eligible?
I suppose he could challenge the administrative decision in that case and to obtain a finding that that prior felony was wrongly scored.
But an agency can trump a court's order.
But that court's order has expired. The case is gone. He has served his sentence. That doesn't flow with him. That doesn't carry on with him forever in all circumstances. It's only if he were to have some harm as applying for a barber, or if he were to commit another crime and his would need to be sentenced. So again, we're talking about speculative events too far in the future for this court to delve into such advisory opinions.
So, getting back to Justice Johnson's issue, it'd be difficult for the Barbers Board, if you will, to try to look at our case law and determine whether he was entitled to relief, because a court has already ordered him to serve his time, and he did. As long as we're speculating, you like to use that word, could he file a declaratory judgment action and get a judgment in a civil court and say, Judge, I'm not asking for any criminal consequences here. I just want you to declare based on the case law that
Sure.
where I am.
I think that's a reasonable avenue. He could also seek some, I suppose, if, like we're speculating, I suppose he could possibly also seek, before even applying for the barber's license, I suppose he could pursue an injunction to prevent a board or some other group from considering that prior because of the way it's been scored, and if he feels it were inappropriate. So, yeah.
Do you think that that action successfully pursued would satisfy Garcia v. Paul? It's an even more speculative question.
Yeah. I think it would probably satisfy the exoneration rule for Garcia.
So it would allow a cause of action to accrue.
I think it probably would. And again, there's not necessarily any right for every cause of action to be pursued to its ultimate end. So I think, again, we're talking about mootness. It's this court's burden both in analyzing the issue and recognizing the fact that cases such as this drag down our dockets. Just one final thing, if I may, Your Honor. I think I heard something mentioned at the very beginning of the opposition's argument about check boxes. If this court is familiar with the record, there was a check box. It's because there were so many of these cases that we had to generate a form to start checking boxes to try to efficiently administer and sort through these cases. That's a problem. And it's a problem that mootness is designed to put an end to. And I think it needs to be applied in this case.
Thank you, counsel.
Thank you.
I just wanted to respond to a couple of things the state said before I close. And I just want to go back to the way Justice Johnson put it, which is and for good reason, we keep talking about, well, what if he wants to do this? And we're drilling down about my client specifically. But what this case is about is whether Mr. Rote's appeal was prematurely ended when he had a recognized legal claim. From a decision that this court says, he'd have a recognized legal claim to have his prior felony reclassified. So it's about, which is mootness. So it's about whether it should have been prematurely ended. Did it meet the 3-part mootness test? And those elements are joined by an and. So even if you feel kind of, well, I don't know, I mean, is he going to be a barber? That sort of thing. There are 3 parts to it, and it is broadly worded and has a high standard that a court has to find before it can prematurely end a person's recognized legal claim. And so while it is important to drill down, and it is also important to step back and just say, listen, the district court in this case and the Court of Appeals, they did not think about all the 3-part test. The Court of Appeals just said, under Montgomery, you're out of here. It did not look at the 3 parts. To respond to another thing that the court said, or I'm sorry, that the state said, was about this idea of when this court has decisions that break wide open these causes of action. I'd never even heard of Garcia versus Ball until I acquainted myself with this case. So I'm going to argue that the sky did not fall when this court issued that opinion 4 years ago. When this court issued its opinion that resulted in Dickey and Murdoch and the forms that the state and I have both referred to, those things were not necessarily surprises either. So just the fact that this court's decision breaks wide open something that's a cause of action to correct people's sentences, to make sure they're serving the sentence that the legislature says they should, that's not a bad thing. And it's not something that we should think of as a negative thing.
But
again,
this case is not about your client serving the sentence he's supposed to serve.
I'm sorry.
This case is not about your client serving the sentence he's supposed to serve. He's served it.
Right.
Now we're just trying to look for some other reason to answer the question.
Right, that he still has this controversy because of the way that one of his convictions was classified.
No, I understand that. But
I'm sorry.
the way you made the argument was to use the present tense of changing the sentence that he's serving. That's gone.
Right.
Now we're looking for
The
something else to
right.
keep the case alive.
That's right.
Okay.
That's right.
And your request, I'm looking at your brief. The declaration was this court must vacate Mr. Rhodes' sentences and remand for resentencing. You weren't asking for a reclassification of that one case, and seems like more importantly, does the correction of the sentence in this case effect a change of the record with regard to his prior conviction? If he has a prior conviction for a level 5 person felony, it should have been non-person now, but when we correct the current, isn't that conviction still there?
I think that what can happen is that the district court could issue some sort of an order saying, or some court would issue an order saying, your 1984 Kansas burglary is a non-person, and it would satisfy the
Non-person for purposes of this case, but how could this case, when you don't have the parties that were involved in the prior case, how can that modify that prior case?
It's about the. I don't think that's necessary because he would have an order in this case that says your in this case, your 2009, 2010 cases, your 1984 Kansas burglary is a non-person felony, period.
It just modifies the effect of it going forward. That's what
right,
you're
and then
suggesting.
he'd have this order that could use to satisfy this malpractice thing. He'd have this order that he could take if he wanted to get certain license or live in a certain place, whatever the case may be. He'd have this order in his cases that say this.
You may have an order in between Murphy and Keel that's no longer
Well,
Same-
I was
the
going to
same
say,
circumstance.
and that his thing was ruled on after.
Well, you understand what I'm
I
saying.
do see what you're saying. Hmm.
That what's done in this case is
Yeah.
not necessarily going to apply for time immemorial.
I do worry about that, but I also worry about this, the way that statutes continue to get changed as far as what kind of relief he could seek down the road, and how. Well, anyway. But the fact is that you're right, the law changes all the time. And sometimes that's because the legislature brings amendments and things like that. And so you're right, that is a concern. But the other thing I do worry about is what sorts of things are going to happen in the near future that are going to exhaust Mr. Rote's ability to request any kind of relief in any form down the road.
Before you, and I know we've gone way over, but with your experience, have you ever handled a resentencing on someone where the sentence has been completed? I can't, I'm trying to imagine how that would work. Do you go back to the time in which he was originally sentenced? Is it based on current circumstances? What if the district court judge imposed a sentence that could be longer than what he originally received, even given the correction in the criminal history? How does all that work?
I feel like
I don't know if
I
you've
might
ever
have
done
something
that.
on my desk about that. But to your first point, I cannot think of a time in 13 years of standing next to people like Mr. Rote
Right.
where I went and had to correct somebody's sentence after the entire thing was served. So I don't know how that would work. And since I'm not in that context anymore, I don't know how people have been handling these situations that would probably look like this.
I mean, you can correct the criminal history, but still end up with the same sentence or even longer, possibly.
Right. Right, because in the meantime, maybe you got a new conviction.
Or
and
whatever.
Or, you know,
Yeah,
or
there's all
whatever,
kinds of
All
circumstances.
kinds of ways that could play
So
out.
I'm just
Right.
curious how that.
But unfortunately, I don't have personal experience about how that would work.
Counsel, you're way out of time.
I know. Anyway, I know that was my stated remedy. I wish I could restate it, but thank you for your time.
Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.